Plain English involves a few different things. One is thinking about the words that you use and how you say them, the sentence structure, the layout, so the general appearance of the document. And another one is who you're writing for, so who your audience is, and thinking about how to produce a document that's clear and easy for them to read and understand. Like any piece of communication, writing is a two-way street. There's the writer themselves and the information they're trying to get across, and the reader and the information that they obtain from the document. It's all very well to write a document that says what you want it to say, but the real question is, does that message come across to your reader? And so it's really necessary when you're writing to think about who your reader is and how they're likely to understand the document, what their level of education is, what their sophistication is, what information they might already have, what they're expecting to hear, whether they're likely to read it in a particular way, so that as you're writing, you're thinking all the time about how the words that you're writing will actually sound in the reader's ear or sound in the reader's mind. A really good example would be something like a letter of disclosure, which is something that we as lawyers write all the time. A real difficulty with disclosure letters is that we're required to write them either for professional indemnity purposes or for statutory purposes. We've got an obligation to write those letters. And it's a professional obligation that sounds either in our insurance policy, or there can be implications for our practicing certificate if we don't actually make the disclosure. So the difficulty for lawyers is it's very tempting to write your letter of disclosure with one eye on the professional body who's actually administering your practice, rather than thinking about who your client is and what the information is that you're trying to disclose to them. But the critical thing is the client actually needs to receive the information. If you write your disclosure letter so that you're thinking about your PI insurer, the PI insurer is a very sophisticated body, and they understand the context and the reason why you're writing a letter, and they don't need a whole lot of background information. They can read a disclosure letter as a very sophisticated person. But most of the time, the reason that you're making a certain disclosure to a client is that they're not very sophisticated, or this is a new area to them, or it's a situation that hasn't arisen for them before and they're not aware of the pitfalls. What you actually need to communicate to your client is very different from just a tick box exercise of, oh yes, I need to make sure that their PI insurer knows that I have said X, Y, and Z. The temptation is to write these very long, detailed letters that provide every single possible permutation with a lot of legalistic language, because that's the language of the statute or the PI policy that we're responding to. But that doesn't help the client at all. What the client needs is to understand what the problem is, what the potential pitfalls are, what the pros and cons are, and understand that in a way that they can make a fully informed decision or take practical steps in their own interest. One of the problems is that people just don't read documents, and there are plenty of studies and user testing research that shows that when people are faced with a document that looks hard, they just don't try, or they make a very minimal effort and give up. And you can't blame a reader for that. We all have had the experience of seeing a document that just looks too complicated. So another problem, or another possible consequence of not writing clearly, particularly when you're giving a disclosure to a client, is that inadvertently you write something that is ambiguous. You think you've written one thing, your client, the reader, reads it and gets something quite different out of the document. And it takes then some time for you to realise that you and your reader are at cross purposes. That can take quite some time to sort out, and as you can appreciate, can produce a very unhappy client. And obviously, if the client then takes steps which they think they are taking based on the advice that they think they've received from you, they might do something that really is not in their interests or is contrary to the advice that you have been intending to give them. There's an inclination to think that when we talk about plain English, we mean that things just need to be simple. That's not actually the case. There's a very important distinction between things that are expressed clearly and things that are oversimplified to the point of being meaningless. When you have complex information to impart, it's important to be as clear as possible in the way that you express this complex information. Acknowledge to yourself it's going to take time. Nobody can write complex information clearly, quickly. And there's that famous line that somebody, it might have been Winston Churchill, said, that I wrote you a long letter because I didn't have time to write you a short one. It takes time to condense information down and to synthesize it in your own head so that you can express that complex information very clearly. Again, thinking about who your audience is, you should have some understanding and some awareness of what your audience's strengths and limitations are and what level of complexity and what level of length they can cope with. And perhaps if it needs to be something that is very long and voluminous, you might also need to set aside some time to talk about the document with them and to do some face-to-face work. It's a common problem to have a document that you're writing which is going to be read by more than one person in more than one way. And examples would be, for instance, perhaps counsel's advice, which will be read by the solicitor, but is very likely also to be passed on to the client. Or board papers that might be read by a number of different people with a number of different areas of expertise on the board. When you know that a document is going to be read by more than one person and they're going to need to use that document differently from each other, there are a few different things that you can do to satisfy the needs of each audience. So one example, and it's a simple example, but one example would be legal pleadings. With legal pleadings, they're going to be used by at least two different types of people. One is the judge and the other is the lawyers on the other side of the matter. The judge will be coming at your matter cold. They won't be very familiar with the facts. So from the judge's point of view, it's very important that you set out the facts in your pleading in a very clear and compelling way. And that might dictate the order in which you set out the facts. That might, depending on the length of it, dictate whether you have a section for the facts and a section for the law, or whether you intersperse the areas to create this compelling story for the judge as he's reading or she's reading the pleadings, so that they can approach the matter with that understanding already in mind. The lawyers on the other side, or the party on the other side, are coming at it very differently. You can assume that they know the facts intimately because they have lived and breathed the dispute in the same way that your client has. That's why the dispute exists. But the pleadings are a fantastic opportunity for you to convince the other side that legally they're very likely not to succeed. And now would be a very good time to start talking to you and thinking about paying you a whole lot of money to make the problem go away. So whereas the judge needs to have a clear understanding of the facts and the story that gives rise to your entitlement for relief, the other side needs to have the law presented to them in this very compelling way. You need to make sure that you're addressing both aspects of the case in that way in your pleadings. Both the judge and the other side are going to read it very differently.